All right, welcome everyone to this webinar. We're back to the FTX webinar mini-series. I'm Sarah Tulin, Head of Growth for sFOX, and today we're going to be discussing how to navigate the bankruptcy of FTX based on your potential claim. Before we begin, we do have a quick disclaimer that this information is a general description from sFOX only. Before acting on any information, you should consider the appropriateness of it having regard to your particular objectives, financial situation, and needs, and seek advice. No information set out above constitutes legal advice, an advertisement, an invitation, a confirmation, an offer, or a solicitation to buy or sell any security or other financial credit or lending product, or to engage in any investment activity, or an offer of any banking or financial service. Following the recent collapse of FTX, over 1 million users want to access their accounts, digital assets, and funds. Today, we will be discussing what clients can do to regain their lost assets. Joining us today, we have Matthew Kelsey and Eric Weiss from Alston & Bird, as well as John Menino from sFOX. Thank you all for joining us today. Matthew, Eric, and John, can you tell us a bit about your organization and your role there?
Sure. Why don't I start? Good afternoon, everyone, at least from New York, good afternoon. My name is Matt Kelsey, and I'm joined by my partner, Eric Wise. We're both in the financial restructuring and reorganization department of Alston & Bird. We are seated in New York City. We have been practicing together for about 20 years and primarily in the creditors' rights space. And so we have a lot of experience to share. I would just say, what we say isn't legal advice, and it's just for informational purposes only, and it's only our opinions based on limited facts to date.
And this is Eric Wise. Matt already mentioned, I'm a partner at Alston & Bird, practicing in the financial restructuring and reorganization group, primarily on the creditor side, with over 25 years of experience in the space. And we're looking forward to speaking with you about FTX today.
Great. I am John Menino. I am the Chief Compliance Officer here at sFOX. Me and my team, we are responsible for all things compliance related. My background, I came from the TradFi world, where I spent 20 plus years at Goldman Sachs and kind of helping manage through sort of the Dodd-Frank implementation, and so have a great deal of regulatory guidance and knowledge in that space.
Thank you. Awesome introductions. Let's get started. In regards to the bankruptcy filings, who are the key players in the case?
Thank you. Why don't I start off and explain the basic insolvency law in the US, which is interfacing with FTX. So the basic bankruptcy law is known as Chapter 11, which is a rule for reorganization. In order to initiate a Chapter 11, which FTX has done, they file a petition. So a case is initiated by a party that is facing financial distress, such as FTX and all of its related corporations, by filing a petition. And the first thing that happens when you file a petition in bankruptcy in Chapter 11 is there is what's called an automatic stay, which is a statutory injunction or prohibition on any creditor, including any account holder, taking action against FTX, which we'll also call the debtor, because once a party files for bankruptcy, it's known as the debtor. So the players in a Chapter 11 case are, of course, the debtor, the FTX entities that have filed. There's the judge who supervises the proceeding and makes findings of facts and gives orders and authorizes actions by the debtor from time to time. There is also a U.S. trustee. You'll hear about the U.S. trustee. That's a statutory person or entity that represents the interests of the United States in a case, including one of its duties is the formation of a committee of unsecured creditors. Another party in the case is the Committee of Unsecured Creditors, often referred to as the official committee, That committee is a group of fiduciaries selected from various account holders and other creditors of FTX, and is then interviewed by the U.S. trustee, and the U.S. trustee selects 9 people who will sit on that committee, and they act as a fiduciary, or they're responsible for all the other unsecured creditors in the case, and they represent them. And the costs and expenses of that are borne by FTX or the debtor here. And they're there to solve the problem of having a multiplicity or many unsecured creditors or account holders, and to give them a voice in the case so that they can get a fair and the best outcome for them.
I would just note, Eric, on top of that, one of the features of Chapter 11, unlike the Bahamas, which is what you're going to talk about, is that the debtor, in this case FTX, operates with its current management. Obviously, SBF is out, but John Ray, who is the chief restructuring officer, which is really no different than a chief executive officer, except his focus is on, the restructuring or bankruptcy process. They're going to run the show rather than a third-party fiduciary appointed by the court.
So those are the cast of characters. One thing that happens at the outset of a case is that the property of the estate separates from the debtor, and the debtor, which is FTX now, and the management group, including John Ray, the CRO, is responsible for managing that estate so that it can be gathered to be distributed to creditors in accordance with their various priorities. I want to also mention there's a Chapter 15 proceeding going on at the same time. A Chapter 15 proceeding is designed to recognize a foreign proceeding or a proceeding going on in another country. And in FTX's case, there's a proceeding going on in the Bahamas, which is a liquidating proceeding. The Chapter 15 is intended to coordinate and enforce, to the extent enforceable in the United States, the outcomes of decisions made in the Bahamas with respect to the number of entities, the limited number of entities that are subject to the Bahamian process. So you'll hear something about Chapter 15 probably in our discussions, and that just means that there's a Bahamian proceeding going on in another country, and that there's a mechanism under the Bankruptcy Code of the United States to recognize that. And there will be some dialogue between the two countries, the United States and the Bahamas, in the context of this bankruptcy, to try and come to a coordinated process between the two jurisdictions or countries.
Thank you. That was definitely, it's helpful to understand the players. And I do have a question to come back to on the differences between both entities. I just want to remind, however, participants, as we have a number that have been joining in, that the Q&A box is open. This is a session where we have topics we'll be discussing on how to go about providing a claim for the FTX filing. And we're going to be going into that a little bit more in depth later on, but the Q&A box is open, and we're going to have time towards the end of the hour to answer some of that. So while we're speaking, if you have a question, feel free to use that box, not the chat box, the Q&A box. Let us know if you have a question directed towards someone specific on the panel, and we'll do our best to get those questions answered. And of course, there will be a recording afterwards as well. So sorry for that little interruption. Coming back to the conversation, can you let us know a little bit more on the differences between the US and Bahamian entities? They're going to be having to cooperate, but what does that look like exactly?
Sure. Well, in the United States, you have the various entities that filed under Chapter 11, and they're going to be following a process under Chapter 11, which works towards a plan which is proposed by FTX, or at least FTX has the right to propose it exclusively for as long as 18 months in the case. And that plan will establish how distributions are going to be made, And during the process of the case in the United States, the FTX entities that have filed will be conducting, under the supervision of John Ray, an investigation into what happened, where the assets are, and also an exercise to get the assets back into the enterprise for distribution in connection with a plan. So that's sort of the goal. With respect to the Bahamian entities, the liquidators have taken control of several of the Bahamian entities, and they have a process that I would say is similar. It's not directed so much towards a reorganization as Chapter 11 is, and it's governed by Bahamian law, but they will be working towards similar purposes, which will be the recovery of assets into the Bahamian entities under Bahamian law, and then a distribution. And for the enforcement of that in the United States, the Bahamian entities will look to Chapter 15 and the approval of the court. This will be done with the same judge in the same courtroom in a parallel process. And if all goes well, it will be a coordinated process which will produce, I won't say the same results for all creditors, but ones that are consistent.
Certainly helpful to understand that difference. What types of claims can be filed, and how are those going to be prioritized?
Okay. Generally speaking, there are a variety of different kinds of claims, but they can really be summed up with three distinctions with like a footnote. One is a secured claim, what's called a secured claim. What is a claim? A claim is a debt that's owed to a person or entity by a company, a debtor, right? A company in bankruptcy. So when you have a claim, what that means is that the debtor owes you money for goods, services, or something else. That claim's repayment could be secured by a lien on an asset, right? And we would call that a secured claim. You know, to demystify what that is, in the most common way to think about this is a secured claim is the claim that a bank has against a borrower in connection with a home mortgage loan, where the claim of the bank for repayment of the loan is secured by a lien in the house. And so that if payment is not made, the bank has the right to foreclose on the house, sell it, and the proceeds of the sale of the house are exclusively for the use of the mortgage lender. And that same process is what a secured creditor is. The secured creditor has first dibs, so to speak, on the value of the collateral that's securing repayment of the claim. Probably most interesting for the listening audience here is unsecured claims. And those are claims, again, debts owed for goods, services provided, or monies invested for which promises were made to give money back, but the debtor never kept its end of the bargain or filed for bankruptcy before it could perform. And that claim is beneath, in terms of priority rank, comes second to secured claims in the sense that it is only entitled, unsecured claim is only entitled to a distribution of assets that are unencumbered by liens or security interests, like a mortgage. So there will be assets here. I think most of them are unencumbered. I'm not aware of any significant secured debt. And so the assets should be available for distribution to creditors. Importantly, though, even as between unsecured creditors, there are different priorities in terms of repayment. Some are statutory under the bankruptcy code, meaning that the bankruptcy code itself creates more favorable treatment to particular kinds of unsecured claims as to other unsecured claims. I don't think any of them really matter here, but to give you an example, you may have a claim as a ex-employee to wages, salaries, and that claim is given a priority up to a cap over other kinds of claims because Congress has determined that there's a particular hardship if a bankrupt company hasn't paid part of your wages or salaries. Another kind of priority is what we call structural priority, meaning that your claim may be an unsecured claim, but at a debtor entity that is subordinate in rights to the value of an asset as compared to another entity that's closer to it. So to give you an example, if you have two companies, one owns the other, and you have two unsecured creditors, one at the subsidiary and one at the parent, the assets of the subsidiary company would be used to be pay the unsecured creditor first. If there's any surplus, that surplus would go up via the equity holding of the parent and then be available to the unsecured creditor at the parent company. But the unsecured creditor, based on its relationship to where the asset is actually structurally, we call it structural subordination. So those are basically the flavors of the claim. The very bottom of claims is not really a claim, it's an interest. Those are equity interests in the enterprise. Those get paid only when creditors are paid in full.
Certainly helpful examples there. It's a great breakdown. I'm curious also to understand a bit more on what we learned from the first hearing from last week.
Okay, so that's right. Last week was the first day hearing, and it was unusual in the sense that the first day hearing typically takes place a day or two after the petition is filed and the automatic stay is activated. The records were so poor by the prior management regime by SBF that the debtors required an additional 10, 11 days before they could really file pleadings, a declaration to tell their side of the story of what happened, and then initiate a hearing. So the hearing happened like 11, 12 days after the filing. And we learned a few things at the hearing. First is that at least through early January, it seems as if the debtor is only going to use $22 million of cash, which, while not an insignificant amount of money relative to the cash on hand, which I think is in excess of 800 million, and relative to the task in front of John Ray and his team is so I say relatively modest. I think most people, no one objected, and I think most people believe that claim holders and account holders and creditors would be much better off with a stabilized FTX debtor. And the way to stabilize that is to, implement controls, do a proper accounting, and trying to figure out where the assets are so that people understand in a better way what their rights and legal entitlements are. And I don't think anyone knows that yet based on what's been filed. And so $22 million seems like a pretty good investment on the long term to stabilize this entity and position it so that it can maximize the value of its assets. The second thing we learned is that both the debtors and the creditor community are very sensitive to issues of confidentiality. Just to take a step back here, in a bankruptcy case, as a matter of policy and law, disclosure is sort of the touchstone of a bankruptcy case. Clear lines of sight into who, what, when, where, and how much, what are the assets, where are the assets located? Do you have claims and causes of actions potentially against whom? And who do you owe money to and how much? And that's all good and healthy, except in this context, what the debtor has said, the position the debtor has taken is that, in fact, the identity of our customers is a confidential trade secret, and it would harm us, FTX, to disclose their identity. In addition to that, there's also the interest of the creditors and account holders and claim holders as well. And Eric and I spoke in court at the first day hearing and said, there's another side to this coin, which is the potential risk of being publicly identified as a customer or an account holder of FTX, given the cybersecurity risks at FTX, given the lack of controls and protocols, which was of course played out really the day the FTX filed for bankruptcy. A significant amount of Bitcoin was stolen from the estate. And so what the judge has done in that case, hearing sort of both sides, has decided to permit the debtors to keep customer information, including names, confidential. And there's going to be a hearing on December 16th to see whether or not that will continue. For those, following closely at home, I will say that, the case law on this question is up in the air. There's two known precedents that I'm aware of. It's Celsius. Judge Glenn said you can't keep confidential the identity of your creditors. You can keep confidential contact information of individual creditors, but not their name. And Judge Wiles came to a different conclusion in Voyager and said, for the safety of others. So it'd be interesting to see how it'll come out. Judge Dorsey definitely, understood the push and pull between the policy of disclosure versus the real risks to people and the dangers of cyber hacks. So those are two very important things we learned at the hearing. I don't know, Eric, if you have anything else to add on that.
Oh, you're on mute, Eric.
I would just note that, as Matt mentioned, we stood up on behalf of account holders to make that point about confidentiality. And it will be an important one that will play out in the case. And another feature, which I'm sure you'll hear about, is that the debtor has sort of organized itself, that's FTX, into 4 different silos known as WRS, Alameda Ventures, and .com. And they've done that in order to segregate out various parts of the corporate structure to help them manage as they focus on investigating and asset recovery. And I think one of the features of this case will be an extensive investigation to try and reconstruct books and records, and a very challenging asset recovery process, because as we all know, cryptocurrency is difficult to find and easy to conceal. And so it may be harder than in some cases, or take more effort to make those recoveries. And so as those recoveries are made, we'll start to see where values may be breaking for various account holders. And then the last thing I want to mention real quickly about the case is that some account holders may be parties that are entitled to a return of their property, and other account holders may be entitled only to an unsecured claim, or it's possible that all account holders are entitled to an unsecured claim. And it's also possible that some will be a combination of a right to payment and a return of property. So I just want to make that point, because as you're studying the claims from an account holder perspective, you'll see those differences start to percolate up.
Definitely lots of learnings and much to come. I want to turn it to John. We saw the Senate Agriculture hearing take place today. What were your thoughts from this?
Yeah, so, I think today was the first of many congressional hearings that we're going to start to see on this. The Senate Ag Committee today brought CFTC Chairman Rosalind Benham to the committee. He was extremely impressive today. He was well-spoken, extremely knowledgeable, clearly laid out kind of the CFTC's role in basically the whole sort of saga that is going on. He clearly defined kind of what they can and cannot do under sort of current law. It was a very, very impressive session. In a way, when you look at someone who is a major regulator and the head of a major organization, he definitely instilled confidence, in the entire panel that was there. I think, it clearly laid out, there were several key points that I would kind of highlight. One is, he clearly laid out the difference between FTX US and then FTX.com, and the big broad issues that have been happening with FTX.com, and how the regulatory framework under the CFTC enabled, good, clear segregation of assets, clear visibility into the books and records. It's almost as if they were two sort of separate, distinct companies run almost sort of completely differently. As someone who kind of has the battle scars from the Dodd-Frank implementation, I do find it quite ironic that the crypto derivative industry is regulated and has much better controls than the crypto spot market, right? And so, I think, another kind of key point that he sort of underlined there was, this ability to kind of clearly define what would be determined as a security, and which cryptocurrencies would be securities and which cryptocurrencies would be commodities, and have a clear line of path over whether the SEC or the CFTC would have jurisdiction over that. I think the big hole that we have right now is just like there's no clear definition of that, and the CFTC is looking for some guidance from Congress and a congressional action to implement clear guidance with that. And the last thing I would just sort of say with that also is just there was a lot of talk about, there's another act that's out there, which is called the DCCPA, which is the Digital Commodities Consumer Protection Act. There was a lot of questions around, would this act, if it was law, prevent a similar type of action that FTX has occurred? I think the answer to this was it would help, and it would kind of give good, clear guidance. I think, there is a view and Chairman Behrman's view is, they definitely want to go back and make sure that they've plugged any potential gaps that they may still have seen in this space. But I think overall, the session was very well received, very informative, and a really, really, positive step. And I think in sort of having the CFTC have regulatory oversight of the crypto spot trading market.
Yeah, no, it's definitely interesting to see all of these different pieces come together. Speaking of which, yesterday, SBF had his first live appearance at the New York Times Deal Book Summit. What did his attendance, what do you think about that?
Yeah, so first off, right, night and day between the two, Chairman Behrman, his presence and how he came across and how he came knowledgeable, and then SBF, it was if I could be quite blunt, I felt it was I couldn't not look away though. He seemed very nervous, very fidgety. He stumbled kind of just sort of answering some basic questions, and over again, he basically just kind of kept saying this, well, I messed up, or I screwed up, and that answer, that's just not going to fly, right? That's not an acceptable answer. And, he kind of pleaded ignorance on a lot of different things. And you're like, okay, you're the head of this company. You're the CEO of this company. You need to know what's going on. And he kind of really tried to distance himself from Alameda. There was a lot of just sort of troubling things that, were said, Matthew, to your point earlier, with regards to, basically, $500 million came off the platform after the bankruptcy filing. That's a major control gap. and he said, oh, well, he kind of attributed this to three different things. He said, one of it, he said he believed that some of it went to FTX US actually. And then he said, some of it was, at the request of Bahamian authorities. And then some of it he basically attributed, to bad actors potentially internally within FTX. He really, really exposed himself, and I think, shot himself in the foot multiple times. I think, the House Senate Committee, Senate Finance Committee is going to want to have him testify there. I don't know if he's going to come in person. I think, during the New York Times interview yesterday, they asked him point blank, like, what do your lawyers think about doing this? And, he basically said, that they discouraged him from that, but he felt like he wanted to, kind of clear the air, which I think he was not very successful in doing. I think it ended up kind of creating much more questions than really sort of, full answers. And then, and what may be the biggest understatement of all time, and the quote that I kind of took away is, quite humorous in this overall really horrible situation where, he basically said, I had a bad month. And I mean, if there was ever an understatement on anything, I think that one is it. So.
Yeah, no, it was definitely interesting to watch. Eric, did you have some comments there?
Yeah, I was going to say it's very interesting to watch, because part of what's happening, I think, in FTX is the intersection of sort of the tech ethos of scalable enterprises. As of according to the debtor, as of October, I think 31, they had 520 employees managing 50 some billion dollars worth of assets, right? If it were a regulated bank or exchange with normal risk management protocols in place, whether required by virtue of regulation or just common sense, you would need a vastly larger number of people simply to maintain that risk management structure. And so I think you get an element of possibly SBF's not understanding what's happened, that it's the growth of a scalable company, and you end up running a multi-billion-dollar exchange like it was Candy Crush, and there you get SBF completely puzzled about what's happened.
Yeah, and that leads me right into the next question. We know FTX filed Chapter 11 bankruptcy in early November. From what we have seen play out since, what do you see as the reasoning behind the filing?
Well, what I think is the FTX desperately needed the benefit of the automatic stay, which Eric described. So one of the key protections of the bankruptcy process to a company that avails itself of it is that there's an injunction or a ban on any act to gain control over property that's held by the company or the debtor's estate. And then the lead up to this filing, it appeared like there was, for lack of a better word, a run on the bank. And people, a lot of withdrawals, which caused, was going to trigger a liquidity crisis. They needed it to stop. And I believe they filed the case in order to preserve the assets that they had in and to make distributions to creditors based on like recognized priorities under, U.S. restructuring laws, as opposed to rewarding the most aggressive or the first to win the race. So the automatic stay is actually designed to not pick winners and losers based on how aggressive you are, but based on, the character of the claim or, debt claim that you have against the company. So I think that is really the primary catalyst. And then I think, that breathing room and asset protection is going to allow John Ray to implement necessary controls, do the investigations that kind of need to happen for potential asset misallocation or unauthorized transfers. And then you have to figure out where assets are and which one of the silos that Eric mentioned they belong to. And then you got to make a distribution of those assets. In the case, the question is, how does this case play out? Does it play out as a one or more asset sales, which is a kind of liquidating the company, but by business line as a going concern with a distribution and then lawsuits? Or is there a reorganization plan where you would potentially equitize people's claims, or is there something in between? Or is there another buyer of one or both of FTX.com and FTX US? It's very, very hard to say, but it seems to me that the predicates for any of that really are understanding assets, liabilities, and the transfers that happen, so that people get a sense of what's out there and what the claims pool are, and so they get some kind of feel for what recoveries might be.
Yeah, I'm curious, you touched a bit on, how the court proceedings will play out because of the filing. I don't know if there's any other comments there, but I'd also love to dive into explaining the FTX asset sales.
Well, one thing to keep in mind that will happen in the next few weeks is the formation of an unsecured creditors committee. If you remember from my earlier remarks, that's one of the important players in the case. It's a fiduciary for the account holders. Right now, in terms of that process, the U.S. trustee is taking applications from account holders and other unsecured creditors for people who want to sit on the committee. Once that committee's composed, that committee will immediately begin to act to assert itself in the process. Following the formation of the committee, there will be a second-day hearing in January, and we'll hear more from FTX and from John Ray and from his team about where they're going. And we'll also at that point hear probably from the official committee of unsecured creditors that's been newly formed and is starting to take a position in the case. Part of, I think I mentioned that people fill out an application. Now, if they're interviewed and selected for the committee, their identity does become known on the committee. And they do serve as a fiduciary. The advantages of sitting on the committee is you do have some participation in the destiny of your claims as well as the claims of others. And you do have the benefit of professionals and advisors that are paid for by the estate, as well as all the information attendant with that and an education in crypto bankruptcy. I think that's all for the near term that I see, Matt. I don't know if you see other interesting features in the near horizon.
No, in the near horizon, I don't. I agree with that completely. I would just add, for the benefit of the folks watching this, there is access on the internet to filings in court for free. And in this case, there's a company named Kroll, Kroll. And if you Google Kroll FTX, you'll get right to the site where it has the case calendar, the key players, any document that gets filed in the case, you can have access to. So if you're interested in tracking the case for free, you can do that. If you're, for non-lawyers, it may be a little dull, but it is a source of information, a free source of information. I guess one other thing I would add, Eric, and this really touches on the first day hearing and maybe what to expect. Judge Dorsey, a former Air Force guy, and he came out and gave a speech about individual account holders and decorum in court. There was no questions from any individual account holders. And when the hearing ended, someone popped up with a question and the court sort of shut it down. So there's going to be an opportunity for people to be heard either by the official committee or, you know, an ad hoc group, or even individually. I would think that if you did want to be heard, you know, teeing up something by a filing on the docket, you know, in a timely way to speak to the judge would probably be the best way. I don't think he's going to tolerate a lot of unscripted backbenching from someone that he's not prepared to hear. The first day hearing's different. That's usually, you know, it's borderline ex parte with no notice. Now people have notice when the next hearing is, and I would imagine that he's going to be a little bit of a stickler about who he wants to hear from.
Hey guys, Matthew and Eric, can I ask, you know, because we talked a little bit here, you know, about the asset sale and everything, and we have FTX US, you know, which is definitely a much more solvent part of the whole organization. And I know, like, during the early days of this, when, you know, SBF was trying to shore up financing through kind of Binance, you know, that was kind of one of the sticking points, was that they didn't want to include FTX US in this piece, and it was sort of separated. I'm just curious how you think that this is going to kind of, you know, come about. Like, are we going to, you know, sell it for parts, or are we going to bring it all together and have one potential overall kind of sale and liquidation?
That's a great question, John. Maybe I'll start, Eric, and maybe add in. So just a couple things. The reason asset sales are sort of top of mind for me, one is, as you say, John, right? There was an attempted one before the filing by Binance. And then also John Ray, in a press release after the bankruptcy filing happened, said, you know, we've done some preliminary work at some of the non-debtor business lines that look to be much healthier, way better managed, actually healthy operating normal companies, not managed by SBF. And those seem ripe for asset sales. Presumably value would, at the conclusion of this sale, would flow up into the silo that the non-debtor subsidiary business operation would go. And maybe there's a buyer out there for the whole kit and caboodle. I would think one of the primary gating items for any sale is going to be correcting the thing that Binance was so distraught about and why they walked away, which is, I have absolutely no confidence in any of the accuracy of this diligence. And maybe if once the work of John Ray and his team happens and there's a clear line of sight as to assets, liabilities, issues, controls, maybe there's a sale for the entire concern. Maybe there's a piecemeal sale. I think without the information that Binance understandably wanted before it was going to make an asset sale, before that information is really reliable, it's unlikely seeing a sale that could really maximize the value of these assets.
Yeah, makes sense.
We have about 15 minutes left with this webinar. So far, it's been super interesting to learn all of this detail. We've had a number of Q&A coming in, so we're going to transition to a bit of the Q&A. And if you have questions, please keep them coming in the Q&A box. But a question that I'm sure many are very curious to learn more about that came in was, you know, when filing a claim, what are the deadlines on filing, selling, buying? And whom should these claims be made against?
Boy, a great series of questions, really fundamental.
Yes.
So let me start. So in a bankruptcy case, the court will establish a deadline. The bankruptcy lingo is called a bar date, but all that means is the deadline by which a creditor must submit a claim against a debtor, right? Normally that involves first the filing of the debtor's schedules, which just outlines on a entity by entity basis the assets and liabilities according to the debtor's books and records, or in this case, probably reconstructed books and records to the best of their ability. So once that's set, right, and currently the deadline for the debtors to file that is January 23rd, 2023. So a couple months, then you would expect 30 to 45 days after that, maybe 60, given just the sheer number, could be 90, just the number of potential claimants here, over 1 million. You know, there would be a notice issued from the court and mailed out to everybody in the debtor's records that, hey, here's the deadline to file a claim. There's a form which asks you to, you know, describe what your legal entitlement is from the debtor and why they owe you money and the identity of the debtor, and then an opportunity to either supplement that form with a narrative or documents to substantiate your legal entitlements to payment from the debtor. So there is no deadline yet. I would not expect one before the end of the first quarter of 2023. I could be wrong. This is just speculation, but given the timing on the schedules and statements, the amount of wood I think that John Ray and his team needs to chop in order to get like good, worthwhile numbers, I would expect it to be, you know, not before March 2023. All right, so there's no deadline. You need to assert your claim against the individual debtor against whom you have a claim. And you need to identify that to the best of your ability. And that's important. So you may have 2 or 3 different legal entitlements, and you should be filing 2 or 3 different claims depending on who in the debtor structure owes you that money. And the debtor's schedules and statements may be helpful for you to help figure that out, may not, in the sense that they may not know. They're often imperfect, even on a healthy-ish company that goes in. I mean, you know, John Ray said this is worse, unprecedented, and he was active in Enron and Revco, right? So this is truly a kind of worst case scenario books and records disaster that he's trying to forensically kind of recreate. So, you know, he's going to need help from the creditor community, account holder community, on the claims process. So the schedules and statements might not be super helpful. In terms of when to buy or sell a claim, there is no deadline for that. And I understand, I don't know, I haven't done any of these transactions, but what I hear from you know, from people who do that is that claims are there's been some claim trading activity in the mid-single digit contexts. So buying and selling a claim 5-6 cents. There's no deadline for that. That's done pursuant to you know, there's a standard documentation for syndicated loans that's usually the basis for trading other kinds of claims. And I imagine over time, there'll be some conventions around that. There is no time deadline on that. You know, as long as there's a willing buyer and a willing seller, you can buy or sell claims whenever you want. You know, obviously the trick is going to be price. Are you comfortable with the price? That's not a legal question, it's a business question. And then there's going to be, you know, things to think about, you know, who's taking the risk of allowance or disallowance. There's a lot of other factors to think about as you're documenting the sale, to position yourself, you know, in the best case scenario. So really the only risk you're taking is what's the amount of the distribution is going to be higher or lower than what I paid. Meanwhile, the seller's thinking, I just want some liquidity now and I need to walk away. I don't know, Eric, if you have anything you want to add on that.
An important thing to keep in mind is that if you are an account holder, at some point before the bar date, which will be set by the court, as Matt mentioned, you'll need to file what's called a proof of claim. And the proof of claim is a form which you fill out, and you may need to fill out with the assistance of counsel, depending, which is an important process point in essentially, I want to say, perfecting your claim with respect to the particular debtor. So if there's something that you take away, it's that's an important thing to do, because those who do not file a proof of claim with respect to the claim can lose their interest in the case.
Another question that came in that goes along right alongside this is how to estimate the value of your claim when approaching this, looking into buying or selling. Any thoughts there?
There's a great deal of complexity around the claims, because if you hold, for example, a custody account, it may be that you're holding a right to return of property, but it's also possible that you don't, because in this particular instance, there is not a lot of law around how custody arrangements work with crypto. And so in part, these cases, and this case, will be determining what the law is with respect to whether or not you're holding a right to return of property or whether you're holding an unsecured claim. Generally, the rule of thumb, when you're estimating your unsecured claim, if it's contingent, you would identify it as contingent, and you would want to put down the maximum possible claim that it could be. But I want to emphasize that we can't give advice over a webinar here, and because there are a large variety of different accounts and account holdings here, it's going to be very particular. The value of claims, though, for example, could be what the value of a coin was on the petition date, or it may be a fluctuating value depending on the changes in the value, and it may be simply a right to return of property. So there are lots of things to think about. I wish I could give our viewers better answers. I can give you some confidence that as time passes, better answers will develop, and there'll be lawyers like Matt and I to help with that.
Yeah, certainly. It's definitely complex. And Matt, I think you have some thoughts. I see you on mute.
Yeah, sorry. I just wanted to add one other thing. I agree with everything Eric said, obviously. But one way to think about your claim, too, right? There's some complexity, obviously, right, depending on the currency that you're going to get paid in. Is it going to be a fiat or cash, or is it going to be, or like stable coin, or is it going to be a more traditional crypto? And when does that get measured and all that, right? But what you really think, I think of it as a ratio, where the numerator is the assets and the denominator of the entire claims pool. When you think about your claims, I mean, this is pretty simplistic, but your claim amount in a perfect world, the numerator exceeds the denominator and you'll get paid in full. Here, right, you're going to need, no information's perfect. And I'd imagine some of the assets are going to be contingent and speculative, meaning that there are going to be litigation claims against third parties that, for inappropriate transfers or preferences or breaches of fiduciary duties or mismanagement or, fraud, right? And those are going to be difficult to value. And because they're difficult to value, as you think about that, the value of the numerator versus the claims pool, that's where, are you taking a bet on a litigation being worth more or less, or do you want the liquidity now? So that's really like the claims trading does help on the liquidity front in terms of peering into the future, I'm just a lawyer. I'm not an investing professional, and I don't do this, but I do know that what the driver is going to be not just the crypto assets, which are fluctuate in value, but really contingent assets, which are litigation claims. They really are assets, but they're very hard to value. And there's a lot of risks in them. Some Eric mentioned about the nature of the species of the transfer. If they were done in crypto, it might be hard to identify the recipient, and it might be hard. You never know, what a judge is thinking. Litigation is kind of inherently risky, because of that. And, maybe there's like good facts, but they're hard to get at. So these things are tricky and they all influence the value of the recovery, which today we don't have a clear line of sight on.
Yeah, no, it's definitely. I have one more question from the audience and then a final closing question. What would you consider fraudulent transfers? You mentioned that briefly, but any thoughts there on some examples?
Sure. There are two types of principal fraudulent transfer claims. One is for what's actual fraud, where you transfer an asset with the actual intention to defraud a creditor or the account holders in this case, and those can be clawed back via litigation by the estate to be brought in. And then there's something that's called a constructive fraudulent transfer. Constructive is just a magic legal word that's used for it, but what it means is a transfer that happens when a entity is insolvent for less than what's called reasonably equivalent value. So what came into the estate is not equal to the value of what went out on a rough basis, and you were insolvent. And those can also be clawed back in, whether or not they were done with any intention. And then lastly, there's what's called a preference. And so if you were, for example, an account debtor who pulled out your crypto and put it in cold storage within 90 days of the case, that can be clawed back, subject to some defenses like ordinary course or new value, can be clawed back into the estate. So some account debtors may actually face litigation to return property that they received. And the final point that I'll make, to the extent that someone made a withdrawal like that and they were an insider, meaning they were an employee of one of the FTX entities or a shareholder or another affiliate, that insider who's made a withdrawal within a year might be forced to put it back. That's the basic lay of the ground of fraudulent transfer and preference.
Right. I would just add, I agree with all that. As we do look back periods for preferences, there are look back periods for fraudulent transfers too. Under the bankruptcy code, it's 2 years. What's interesting is the bankruptcy code allows an estate fiduciary to opt to the state law. And in New York is 6 years, I believe, Delaware 4, and other states have different ones. So you're looking at transfers that go back some ways. So they're and if they were bad at the time that they were made, either bad in the sense that someone had the specific intent to defraud, or if you can't prove that, at least constructively, it's a fraud in the sense that you were insolvent and you didn't get reasonably equivalent value back. You have a live cause of action. They are very fact intensive litigations to launch. But potentially here, given what we heard, we've been talking about, nine figure snatch of assets on the day it filed. God knows what happened before. And who knows, as between silos, how they're going to reconcile transfers and whether one silo is going to dig their heel in against another silo. It would seem to me that there's strong potential for fraudulent transfer litigation in this case.
Yeah, definitely sounds like it. We have one last question that we want to wrap up on. What can people do to avoid being caught up in similar situations like FTX moving forward?
So yeah, I'll kick this off, right? I'm gonna say 3 quick things, right, that potentially there. Number 1 is a pretty basic one, right? It is continuing to do your proper due diligence on this. Ask questions, make sure that you're getting the answers that you are comfortable with and that they're clear. So that is always, always, always a key one from the get-go. Number 2 is the option to store your items in cold storage, right? Cold storage is not without its flaws, and it's very difficult for a high frequency trader, et cetera, to kind of do that, but that is an option. The third one that I would really want to highlight, though, is a very, very important product offering that sFOX has, actually, that is, our safe custodial, our safe trust company, which is a licensed trust company under Wyoming law and under the supervision of the Wyoming Division of Banking. This offers a great alternative and offers a good amount of bankruptcy protection in the event of any type of insolvency. This is a great offering, and I definitely would point them back to you, Sarah, anyone who has questions on this, because this is a great way to really sort of help protect yourself on a go-forward basis.
I think that's exactly right. I think at the end of the tunnel with FTX and other crypto exchange failures, there's a regulatory regime that's going to dovetail with all this restructuring. And between here and there, between here and arriving at a satisfactory regulatory regime, you need to look for self-regulators, firms that, when we say due diligence, find out how they're managed, find out, do they have a compliance officer? What's the experience of that compliance officer? What are their internal controls? And if you're not satisfied with that, the answer is minimize your risk with those exchanges by cold storage or otherwise seeking out regulated entities in Wyoming or otherwise to make sure that you're managing your risk.
Certainly helpful. Matt, did you have any other last words on that?
No.
I know that was covered.
No, nothing to add. That I couldn't agree more with what John and Eric said.